1.331B, and count 2, obstructing official business, a felony of the 5th degree in violation of revised code section 2921.31. It is my understanding today, Your Honor, that the defendant wishes to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, failure to comply with order or signal of police officer, a felony of the 3rd degree. Upon the court's acceptance of that plea, the state will ask that the remaining count be dismissed. Thank you.
Ms. Clapp?
Your Honor, that is accurate. I have reviewed with Mr. McDonald the offer, and he has indicated that today he would like to take that and go through the proceedings to enter his guilty plea. Thank you.
All right, well, on count 1, the indictment says the operation of the motor vehicle causes substantial risk of serious physical harm to persons or property. So is there some agreement on what that means or what that is, whether it's a substantial risk of serious physical harm to persons?
No, there's not an agreement as to whether it's persons or property.
Okay, because I'm not making a finding.
Understood, Your Honor.
Okay, so this
It's in there, but it's not, it says both, I think.
all
I
right, well,
believe.
I'm only going to instruct him on PRC for up to 2 years. I'm not
Okay,
going to
yeah.
instruct on the 1 to 3.
Okay, Your Honor, thank you.
Okay.
No. Still asking for a pre-sentence report.
All right, Mr. McDonald, how old are you?
25.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes,
Are
sir.
you able to read, write, understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Yes, sir.
What have you been diagnosed with?
Frontal lobe brain damage, post-traumatic stress disorder. It's a number of things. I don't have.
Are you currently being treated?
Not at the moment, no, sir. I'm currently in Lake County Jail.
Were you, before you went to jail, being treated?
Yes.
By who?
I had services with developmental disabilities. I had services with the centers, and I was going back and forth from Metro to Cleveland Clinic. I was going to transfer to Cleveland Clinic, totally to Cleveland Clinic, but I didn't get a chance to do that yet.
All right, are you able to understand what's going on here today?
Yes, sir.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty that I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want more time to talk to Ms. Clapp, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come and testify for you. Do you understand that?
Yes, sir.
Are you going to waive that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come here and testify. Do you understand you have that right?
Yes, sir.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, I do.
Do you understand that by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
Now, failure to comply with the order or signal of a police officer is a felony of the third degree. It carries with it a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Is there a mandatory license suspension on this?
I'm sorry?
Is there a mandatory license suspension on this?
I believe it's a is it a mandatory? You know what, Your Honor, just give me one moment, let me double check on
All right.
that. Yes, it is a mandatory Class 2 suspension for a definite period of 3 years to life.
All right, Mr. McDonald, do you understand that a conviction on this will lead to a maximum operator's license suspension of at least three years up to your lifetime?
Yes, sir.
Are you presently on post-release control of the parole authority?
No.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control after your release from prison for up to 2 years under the parole authority.
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for that post-release control violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
You understand at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer.
Yes, sir.
Have you had enough time to talk with Ms. Clapp before pleading guilty today?
Yes, I did.
Has she discussed everything about your case and answered all of your questions?
Yes, she did.
And are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
I have not.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
All right. Ms. Hronik, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven with the evidence that beyond a reasonable doubt that on October 30th, 2023, the defendant in Willowick, Lake County, Ohio, operated a motor vehicle so as to willfully elude or flee a police officer, after receiving a visible or audible signal from that police officer to stop the vehicle, and the defendant's operation of that vehicle caused a substantial risk of serious physical harm to persons or property. Specifically, on that date, the defendant was driving a vehicle on the area of East 305th Street and North Marginal. A traffic stop was attempted to be initiated based on warrants that were out for the defendant for fleeing from the Eastlake Police Department. And so when the officer initiated his lights and siren, the driver initially acted like he was going to pull over, then got back into the lane of travel and fled from the police on State Route 2 at a high rate of speed. During the pursuit, the speeds were near about 100 miles per hour. Traffic was moderate. Once they continued on to 90 westbound, traffic got heavier. The vehicle continued to travel at speeds over 100 miles an hour and passed vehicles on the right shoulder while going around a curve and was driving in a reckless manner. The pursuit was terminated due to the heavy traffic and the reckless driving at that time. Thank you.
All right, Ms. Clapp, anything to add to those facts?
No, Your Honor.
Mr. McDonald, did you hear what Ms. Hronik said? The facts would show if the case went to a trial.
Yes, sir.
Are those facts true?
Yes, sir.
All right, what is your plea to failure to comply with the order or signal of a police officer, a felony of the third degree?
Guilty.
All right, Ms. Clapp?
Your Honor, prior to the beginning of court this afternoon, I reviewed this written plea of guilty document with Mr. McDonald. We went over it in detail. He indicated he understood it and that he would sign it in court at the appropriate time.
Is that correct, Mr. McDonald?
Yes, sir.
All right, if you want to plead guilty, you need to sign that document then.
Today is May 1st. That's the date. Sign right there. Your Honor, Mr. McDonald has signed this document. I've witnessed it. I also changed out Conchetta Ragazio's name for my own on the document.
Your Honor, for the record, I witnessed the defense attorney and defendant signed a written plea of guilty in open court. I have signed the same document and am now handing it back to the court.
Mr. McDonald, is this your signature on this written plea of guilty?
Yes, it is.
And did you sign it voluntarily?
Yes, sir.
Do you want me to accept the written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present with Ms. Clapp, advised of all of his rights, made a knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty of count 1. Failure to comply, a felony 3. I'm going to refer this for a pre-sentence report and a psychological evaluation. Sentencing will be June 14 at 11 a.m. and the bond is revoked. Anything else, Ms. Hronik?
Sorry, Your Honor, did you say bond revoked?
Yeah.
Okay, nothing else, Your Honor, thank you.
Ms. Clapp?
Nothing, Your Honor. Thank you.
All right, we're adjourned.
3 CR 001106. The defendant is present in court with defense counsel Antonio Nicholson. Prior to coming into court today, the defendant filed a motion for intervention in lieu of conviction. The state has reviewed the reports and is prepared to proceed with the hearing. The state does not object to the defendant's motion for intervention.
All right, Mr. Nicholson.
Thank you, Your Honor. Good afternoon, Your Honor. Antonio Nicholson on behalf of Mr. Thomas. State is correct, Your Honor. We did file a motion for intervention in lieu of conviction. That motion was submitted to the court. Mr. Thomas did undergo an assessment screening. There was a report provided prior to this hearing. I was able to look at the report, Your Honor, and there, to my knowledge, there are no additions or deletions that need to be met, Your Honor. And we would ask this honorable court to go along with the recommendations of the report. Thank you.
All right, I reviewed the pre-sentence report. Mr. Thomas is eligible, so I'll grant the intervention motion. Mr. Thomas, how old are you?
32.
How far did you go through school?
11th grade.
Are you a U.S. citizen,
Yes, I am.
able to read, write, and understand the English language?
Yes, I am.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No, I haven't.
Okay. All right, so we'll go through your the plea and then implement the terms of the plan. So before I accept your plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want some more time to talk to Mr. Nicholson, let me know and I'll give you more time. Do you understand that?
Yes.
All right. You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, I do.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come here and testify. Do you understand that right?
Repeat.
If the witnesses refuse to come to court, I'll issue an order that's called a subpoena that makes them come here and testify. Do you understand that right?
Oh, yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
All right. Do you have any questions about any of your rights?
No, I do not.
Do you still want to plead guilty to this charge?
Yes.
You understand by pleading guilty, you are fully admitting your guilt to this offense.
Yes.
You understand that by pleading guilty to this felony, that if you are convicted, that you voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
All right, now in count one, the aggravated possession of drugs is a felony of the 5th degree. It carries with it a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification and you're giving up those items listed in that specification, do you understand that?
Yes, I do.
All right, do you understand that if you are found guilty of this offense, it may result in a driver's license suspension of between 6 months and 5 years?
Yes.
Do you understand if you are convicted of this offense, that that felony conviction would prevent you from owning or possessing a firearm?
Yes.
Do you understand if a conviction results in this offense and you are sentenced to prison, then upon your release from prison, you might be placed on post-release control for up to 2 years under the direction of the parole authority?
Yes.
If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
And the maximum prison term for that violation would be either 12 months or the time you have left under post-release control, whichever is more.
Yes.
If you are sentenced to prison, then you are eligible for judicial release. Do you understand that?
Yes.
If you are convicted of this offense, I could put you on community control for up to 5 years with conditions. If you violated the conditions, then I could send you to prison for 12 months. Do you understand that?
Yes.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty today?
Man, I was believing that I was, that I qualified for the.
Okay, I'm going to put you on an intervention plan, okay? If you do not, if you violate the plan, then you're going to be convicted of this offense. Do you understand that?
Yes, I do.
Okay. So if that ever happens, did anybody tell you that I will go easy on you just because you're here pleading guilty to it?
No, not necessarily, no.
All right. If you do violate the plan and at some point get sentenced, did anybody promise you what I would sentence you to?
No.
All right. And in that occasion, if it does come to a sentencing, do you understand if the prosecutor recommends a sentence and Mr. Nicholson recommends a sentence, I don't have to accept either of those. Do you understand that?
I understand.
All right. Have you had enough time to talk to Mr. Nicholson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
And are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Excuse me?
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Okay. Do you have any questions before we get to the next thing?
No.
All right. Ms. Haranik, if this case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that the defendant on October 6, 2023 in Menor, Lake County, Ohio, did knowingly possess methamphetamine, Schedule II controlled substance. Specifically on that date, the defendant was driving in a vehicle with no tags. He was stopped by the Menor Police Department, and a subsequent search of the vehicle revealed a bag on the passenger seat that contained 2 small baggies of marijuana and a small baggie of brightly colored tablets, which were sent to the crime lab. and the results were that it was methamphetamine Schedule 2. The defendant stated that the pills were ecstasy and that they were his. Thank you.
All right, Mr. Nicholson, anything to add to those facts?
No, Your Honor.
All right, Mr. Thomas, did you hear what Ms. Hronik said the facts would show if the case went to trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea then to
Uh,
count one, the aggravated possession of drugs of felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
All right, Mr. Nicholson?
May I approach, Your Honor?
Yeah.
He'll tell you to sign it. Do you want him to sign it right now?
Yeah.
Okay, sign it. Yeah. Just back up a little bit. This is everything. Just explain. Directly.
Your Honor, for the record, I've witnessed the defendant and defense counsel sign the written plea of guilty in open court. I have signed the same document and am now handing it back to the court.
All right, Mr. Thomas, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes, I did.
Do you want me to accept the written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present with Mr. Nicholson, advised of all his rights, made a knowing, intelligent, and voluntary waiver of those rights. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Finding to be knowing, intelligent, and voluntary, will accept his plea of guilty to aggravated possession of drugs, a felony of the 5th degree, and the forfeiture specification. I'm going to state a criminal proceedings at this time and place you on a 3-year intervention plan. You're going to serve 34 days in the Lake County Jail with credit for 34. You're to have no drugs or alcohol, and you'll be screened. You're to obtain a drug and alcohol evaluation and follow all the recommendations. You're to attend at least 3 AA meetings per week and get a sponsor, obtain and maintain full employment, and get a valid driver's license. You know what you have to do to get a license?
Yes, I just got, checked the maneuverability test and, obtained the SR-22.
Right.
Fine.
And you're gonna pay the cost and supervision fees. Anything else, Ms. Randazzo?
Nothing further, Your Honor.
Do you understand the terms of the plan, Mr. Thomas?
Yes, I do.
Any questions about it?
No.
If you violate the terms of the plan, then the state will file a motion to terminate it. If I find you violated, I'll terminate it, and you'll be convicted of this felony offense. Do you understand that?
Yes, I do.
And then all the penalties for sentencing that went through would apply. Do you understand that?
Yes, I do.
No questions at all?
No, I don't.
All right, so the items subject to forfeiture are forfeited and the bond is released. Anything else, Ms. Saronic?
No, Your Honor, thank you.
Mr. Nicholson?
Just briefly, Your Honor, so he will be getting released today?
Yep.
Thank you, Your Honor, nothing further.
All right, we're adjourned.
All right.
counts upon sentencing. We are also set for a plea by way of information on case number 24, CR 00318, where the defendant will be pleading to aggravated possession of drugs, a felony of the fifth degree. There is no agreement regarding sentencing, and the state would request a PSR and drug and alcohol assessment. Thank you.
All right, Mr. Williams?
Yes, Your Honor, that's my understanding of the terms of the plea agreement.
All right, Mr. Morgan, how old are you?
50, sir. Oh, wait, 51.
How far did you go through school?
Ninth grade?
Are you a U.S. citizen?
Yes, sir.
Able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes.
What have you taken?
My psych meds this morning. I can't remember the names of them. Effexor and Boost Bar. I'm sorry.
Does that medication affect your ability to understand what's going on here today?
Yes, sir.
It does affect you?
What are you saying? Is that impairing your ability to understand?
Oh, no, it's not in a bad way. No, it just slows me down so I can comprehend things more.
Okay. All right, in the 22 case, did you get a copy of the indictment?
Yes, sir.
So is it your understanding you're going to plead guilty to count 1, aggravated possession of drugs, a felony of the 5th degree, and the forfeiture specification?
Yes, sir.
And did you get a copy of the information filed in the 24 case?
Yes, sir.
And in that case, you're going to plead guilty to aggravated possession of drugs and the forfeiture specification?
Yes,
Is that
sir.
your understanding? Okay. Now, in the 24 case, do you understand you have a right to have that case presented to the grand jury for them to decide whether or not to indict you? You understand
sir,
you have
there's
that
no
right?
I had it on me. Yeah.
All right.
Or no. What?
You understand you have that right to have
Oh,
them?
yes, 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 yes,
Okay,
yes.
and did you
Okay.
discuss that right with Mr. Williams?
Yes, sir.
Are you going to waive that right?
Yes, sir.
All right, go ahead.
Yes, Your Honor, we have the waiver indictment form here. I have reviewed this with Mr. Morgan prior to coming into court, and I am executing the document here in open court for the record, and Mr. Morgan is executing the document for the record.
Your Honor, for the record, I have witnessed the defendant and the defense counsel sign the waiver of indictment in open court. I'm now signing it myself. And with your permission, I would approach and return it to the judge.
All right, I will accept your waiver on the 24 case.
Thank you.
Now, before I accept your guilty plea on both cases, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you do not understand a question or you want some more time to talk to Mr. Williams, then let me know that and I'll give you more time. Do you understand that?
Yes, sir.
So when I'm going to read you, all these rights applies to both of these cases, okay?
Yes, sir.
All right, you have the constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After those witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, ma'am. Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
And if you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a lawyer, one will be appointed at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they would be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty in both these cases?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In the 22 case, aggravated possession of drugs is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
And in the 24 case, aggravated possession of drugs is also a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
And in both cases, with regard to the forfeiture specifications, if you plead guilty to the specifications, you're voluntarily giving up any right you would have to the items listed. Do you understand that?
Yes, sir.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 24 months and a maximum fine of $5,000. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
No.
Do you understand your guilty plea may, in both cases, may result in a driver's license suspension of between 6 months and 5 years?
Yes, sir.
You understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand that if a prison term is imposed in either of these cases, then upon your release, you might be on post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If your violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months of the time you have left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years on each case, but if you violate the conditions, then on each case, I could send you to prison for 12 months for a total of 24 months. Do you understand that?
Yes, sir.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
You understand at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer.
Yes, sir.
Have you had enough time to talk with Mr. Williams before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Oh, yeah.
And are you
Yes.
satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, no, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No, sir.
All right, Mr. Knopf, in the 22 case, if that case went to trial, what would the evidence show?
Your Honor, had the case proceeded to trial, the state would have shown that on or about the 16th day of September in Painesville Township, Lake County, state of Ohio, the defendant did knowingly possess methamphetamine. Specifically, Your Honor, the defendant was driving a vehicle which was stopped due to having a license plate out. Subsequent search of that vehicle revealed that there was drugs in the ashtray. Those drugs were sent to Lake County Crime Lab and confirmed to be an F5 amount of methamphetamine.
All right, Mr. Williams, anything to add to those facts?
Nothing to those facts, Your Honor.
All right, Mr. Morgan, did you hear what Mr. Knopf said? The facts would show if the case went to a trial.
Oh, yeah. Oh, yes, sir. I told the
And are
cops
those-
the drugs were there.
Are those facts true?
Yes, sir.
All right, then what is your plea to aggravated possession of drugs of felony 5?
Guilty.
What is your plea to the forfeiture specification?
Well, yeah, yes, guilty.
All right. Mr. Knopf, if the 24 case went to trial, what would that evidence show?
Thank you, Your Honor. Had the case proceeded to the trial, the state would have shown that on or about the first day of March 2024 in the township of Painesville, Lake County, State of Ohio, the defendant did knowingly possess methamphetamine. Specifically, the defendant was the passenger in a vehicle. That vehicle was pulled over, subsequently searched. There was drugs found in the passenger door of the vehicle that were sent to the Lake County Crime Lab, confirmed to be an F5 amount of methamphetamine. Thank you.
All right, Mr. Williams, anything to add to those facts?
Your Honor, just that there was several other drugs located within the vehicle, which was not Mr. Morgan's. He was charged specifically in relation to those which were found nearest to his person, Your Honor.
All right. And Mr. Morgan, did you hear what Mr. Knopf said? The facts would show if the 24 case went to trial.
Oh, yes, sir.
And are those facts true?
Oh, yes, sir.
All right, what is your plea then to aggravated possession of drugs of felony of the 5th degree?
Guilty.
And what is your plea to the forfeiture specification?
Yes, guilty. Oh, what you gonna do?
Mr. Williams?
Yeah. Whatever.
Your Honor, prior to coming to court today, I've had an opportunity to review both of the written pleas of guilty on the 22 and 24 cases with Mr. Morgan. I feel confident that he understands the rights that he has, those which he is giving up, and that his plea is knowing, intelligent, and voluntary. For the record, Your Honor, I have executed the written plea of guilty, first on the 24 case. Mr. Morgan is executing that document now. Today is May 1st.
This one?
Yeah, you sign there. And date May 1st, I'll fill that in. Do you need your glasses? You
All
good?
right, no.
Okay.
Your Honor, for the record, the state has witnessed the defendant and the defense counsel sign the written pleas of guilty. The state is now signing them themselves. And that's on both cases, the 24 case and the 22 case. And with the court's permission, I would approach and return the documents.
All right, Mr. Morgan, is this your signature on both the 22 written plea of guilty and the 24 written plea of guilty?
Yes, sir.
And did you sign both of those voluntarily?
Yes, sir.
And do you want me to accept your guilty plea on both of those cases?
Please, sir.
All right, I'll accept the guilty plea. On the 22 case and on the 24 case, the defendant was present with Mr. Williams, advised of all of his rights. He's made a knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty in the 22 case of aggravated possession of drugs of felony 5. I'll find him guilty of, in the 24 case of aggravated possession of drugs, a felony 5, as well as the forfeiture specification in both cases. I'm going to refer both cases for pre-sentence reports. And drug and alcohol evaluation sentencing will be June 12 at 1:30 PM, and the bond is revoked in both cases. Anything else, Mr. Knopf?
Nothing further, Your Honor.
Mr. Williams?
Your Honor, just as far as the substance abuse assessment, we asked specifically that he be interviewed to determine his potential suitability for placement at NeoCap.
All right, we'll do that.
Thank you.
All right, we're adjourned.
Thank you, Your Honor.
of this year, where the defendant pled guilty to the 3 counts in the indictment, 2 counts of domestic violence, misdemeanors of the first degree, as well as count 3, trespass in a habitation when a person is present or likely to be present, a felony of the 4th degree. This matter was referred for a pre-sentence report and victim impact statement, and we're set for sentencing today. Thank you.
All right, Ms. Brenneman?
Thank you very much, Your Honor. Your Honor, it is important to note that my client does not have any prior felony record. He has taken responsibility in this case by pleading guilty to the charges. Your Honor, he has also been in the county jail now since March, has had a significant amount of time to remain sober. He started working on his sobriety right before being incarcerated. However, this has just kind of furthered that goal. Your Honor, he does have children. That was the nature of this case, was surrounding discipline of these children that got a little out of hand. Your Honor, he has a very healthy relationship with his daughters now. He, speaks with them regularly. They have now become adults, and, they're working very hard at progressing in their goals as well. He does have a job that he can return to, Your Honor, working for a maintenance contractor. Currently also lives with his uncle and cares for his uncle. His uncle has some serious leg issues and has to be bandaged daily, and my client does assist him in that process. So, Your Honor, my client is a very good candidate for probation. I think he would do very well. He'd be able to maintain his sobriety and get any further assistance he needs in terms of that path. So thank you very much, Your Honor.
Thank you. Mr. Burr, what do you want to tell me?
Yes, Your Honor, thank you. Just so sorry for wasting the court's time and stuff, but yes, I do have a relationship with both my daughters. I speak with them daily. I just want to move on with my life and continue on my sobriety and my work, and take care of my uncle and seeing my mom and my goals.
Well, Ms. Brenneman said you've taken responsibility for this. What does that mean?
It was a discipline. I was trying to discipline my youngest daughter to go to school, and it just got out of hand, and she ran away, and I found out where she was at, and so I went there to talk to him, and we all got into an argument, and it got out of hand, and that's how it, I guess you're not supposed to walk in when the door's open for you. That's how I got to trespassing, so I didn't know that.
Well, I guess I'm curious about this because I read the pre-sentence report, and it seems like you should probably withdraw your guilty plea and go to trial on this. I mean, because your statement of the probation officer is, this is bullshit, you were just trying to discipline your daughter.
Right.
So then why did you plead guilty?
Because it's 4 years going now.
Okay.
Like, my daughters are grown, and I'll take the responsibility. Like I did, I mean, I'm not saying I didn't hit my daughter, and I'm not saying I hit my daughter.
Well, then what do you?
I did.
Wait.
I
Wait.
I did smack
Wait
my
a minute.
youngest.
Wait a minute. Didn't you plead guilty to domestic violence?
Yes, sir.
So
Yes,
now
sir.
you're telling me you didn't? You maybe did, maybe didn't?
No, I'm not saying that.
What are you saying then?
I'm saying I pled guilty to it,
Okay.
that there's a domestic there. But it was on disciplining my children, that's all.
Well, I mean, you split her lip by punching her in the face. Faith, right?
Your Honor, first, all I did was turn around and walk out of the house. She went to hit me again, all I did was block her hit from hitting me.
How come nobody else verifies that?
She supposedly did, is what I was told. The officers didn't want to even listen to my statement. All they did was handcuff me and put me in the car.
And you slapped the younger one
Yes.
2 days in a row, right?
No,
No?
once.
Once? Okay.
Yes, sir, Your Honor.
See, I think you should have gone to trial. What about busting into the house of this Bossert?
I did not.
You didn't?
I knocked on the door, and she came to the door. She was folding the laundry on the couch. I said, "You need to get my daughters. She needs to come home." And Faith came down, came to the door and I told Faith, I said, Faith, you need to open this door. Hope needs to come home. She's grounded because they ran off to Florida without my knowledge. And she opened the door and that's when I walked in. And I
You
didn't
walked
know.
in, so you weren't pounding on the door,
Nope,
pushing the door in with people trying to hold it behind you?
no, Your Honor. It was only
I
Faith.
I can't for the life of me figure out why you pled guilty.
Because I'm just over it. I don't want a warrant no more. Like, I've been doing this for 4 years.
Where you been for 4 years?
I've been taking care of my uncle. I was taking care of my mother at the time, but it got too much for her and me and my uncle. So my aunt, her sister is taking care of her right now. And I'm taking care of doing my uncle's legs and stuff, cutting the grass so he doesn't get evicted. And taking care of his house, his trailer, I mean.
So when Ms. Bossert says you were pounding on the door, you wanted to come in, she said, you're not coming in, I'll go get your daughters. You kept pounding on the door. Faith told you not to come in. You started beating on the door again, trying to push the door open. Faith was pushing back on the door to try to keep you out. You got in, forced your way in, slammed the door, pushing Faith around, then punch her square in the face, split her lip. That never happened. That ever happen?
It could have happened that way, Your Honor. I mean, like I said, it was over trying to discipline my youngest from going to school. So things did get out of hand, escalated.
I mean, were you high at the time?
No, Your Honor.
Okay. How old were you at the time?
40,
How old are you now?
I'm 52.
Okay, so you were 48,
Yeah, 48.
and you've been smoking marijuana from the time you were 14 every day till you're 48, doing heroin
off
at
and
that
on.
time, right? Meth?
A little bit, not a
Okay.
lot.
So you were completely sober that day?
Yes,
You weren't using at all?
no,
Okay, so you just have a temper problem or what? Beyond the
No.
drug problem?
no,
No?
no, I'm a very patient man and stuff, but
What?
this was going on for months. Like I took Hope out of public school because of bullying and put her in homeschooling, and she was doing it. Then she wasn't doing it because she was hanging out with her sister, running the roads, and I had to go chase and find them, and I was getting in trouble for not doing schoolwork and doing school. In and out of the juvenile court.
Where do you get the idea that the Fourth Amendment allows you to discipline your child as you see fit?
It says that you're allowed to discipline your children.
Well, it doesn't say anything about disciplining children.
Well, that's what we've read. Like my one uncle was doing law, and he did this. He had the exact same thing with his stepson, and he smacked him in the mouth, and it blistered open. And he called the cops. The cops came there and said, "Well, you need to do your chores. He's disciplining you. It's not beating him with a board or nothing like that."
So you were within your rights, what you did, that's what you're telling me.
No, I'm not.
Okay.
It could have went another way, but she needed to understand, like, she can't kick holes in the wall and kick the door off the hinges. Like, that's what she did. Like, that's disrespectful. And she told me to call the cops. Like, who really wants to call the cops on their children? Like, if you're a parent, you need to be a parent. mean, I was trying to disarm the, discipliner myself. Like, I've had custody of both of my children from day one.
How did you surface after 4 years?
Excuse me?
How did you surface after 4 years?
I got pulled over, driving, a loud truck.
And a warrant's been out this entire time?
Yeah, yes.
Did you know the warrant was out?
For a minute I did.
What does that mean?
I was actually going to turn myself in to take care of this situation,
When?
as soon as I was clean. That's what I was doing at the time. Like,
What do you mean, what were you doing to get clean?
trying to get, like, kratom. It's a medicine that helps you kick heroin.
So how long has it been since you used heroin?
Oh, it's 2 months.
When you got picked up?
Yes.
So what, you want to be on probation, right? That's what your lawyer
Yes,
said?
sir.
So what am I supposed to do with you?
With,
Probation.
put me on probation, let them drug test me. I mean, that's not a big thing. Like, I'm in the state of mind where I'm done with that scene. I want to be on with my life. I have more things to do, more things to live for. Like, I have property I want to go take care of in West Virginia. Like, I want to see my grandkids, if I get to have grandkids with my girls, so. I've seen too many friends die. That's not me.
When?
The past 4 years.
Okay. If that's the case, then why are you still using heroin all this time?
I'm not,
Well, you were, right? You got caught in March with heroin.
but I wasn't, I did get caught in March with it, but I was weaning myself off of it. That's my hope.
How do you wean yourself off of heroin? I've never heard anybody wean themselves off of heroin.
It's very hard to do. Like, you only.
Well, how were you doing it? Explain to me what you were
the
doing.
most minimum, not to be sick, trying to find the store that had the kratom.
You got a whole different mindset
Like,
than I can believe here.
it's
No,
hard.
nobody in the history of heroin has weaned themselves off of heroin. I mean, you've been doing drugs since at least you were 14 years old, right?
Oh, smoking some weed, yeah.
Well, that's a drug, right? Is weed a drug?
Apparently it is to the state.
Is it to you?
To me, no,
No?
no. It's more like a tobacco.
So what kind of treatment do you need?
Whatever the court decides.
Well, no,
I mean, probation.
I mean, I'll decide what I decide, but I'm asking you, what kind of treatment do you think you need?
Me?
Yeah.
I need probably probation and maybe an outpatient program, like I've done before,
What did you do before?
like Geauga Center.
When was that?
That's been 20-some years ago.
It didn't work, right?
Yes, it did until my late 20s.
Okay, so it hasn't worked for, I mean, it didn't work, because you right back to doing heroin, meth.
No, I was just
Pot.
smoking pot.
Well,
I didn't start doing heroin until I was 48.
okay,
That's after my dad died. I lost my son. 2 of my best friends passed away. So all I wanted to do was forget. And that was the drug that I was given to make me forget. And I did it for 6 years, and it's not me.
well, I mean, it is you, because you've
No,
been
it's
using,
not. I was using it, yes.
you were using it until you got in jail, and then you're not using it anymore, right?
Yes.
So that was you, at least for the last 4 years, by your own admission, it was you, right?
Yes, sir.
So it's, in talking to you, it seems like you don't think you need any treatment. You can just wean yourself off of by yourself.
No, everybody needs help. I'm not saying I don't need help, Your Honor.
Where's the last place you worked?
RC contracting, 11 years.
And who owns RC Contracting?
Rick Christensen, senior and junior. I was talking to him right before all this happened, and he said I could get my job back at $32 an hour.
The pre-sentence report indicates the last place of employment was RC Contracting, and that you left because of coworkers.
Yeah.
When was that?
4 years ago.
Okay, so what's this Rick Christian? What's that?
Excuse me?
Who's Rick Christian?
Christensen, he's the
Christian.
owner. He's the owner of the company.
So you're talking, so that's, you left there 4 years ago and you're going back there?
I can, yes.
Okay. What have you been doing for the last 4 years then?
Just odd jobs. I'm a construction contractor. I do roofs, patching, grass, trees, plumbing, like electrical, drywall finishing. Like, I'm not a stupid person. I'm a very smart person.
What else you got to say? Anything else?
If you put me on probation, I won't disappoint you.
Well, I don't know, I hate to tell you this, but you don't have the capacity to disappoint me. It just doesn't exist. Ms. Wood,
Thank you, Your
have a
Honor.
seat.
On behalf of the state is recommending community control sanctions. If the court does place the defendant on community control sanctions, I think the jail treatment program, additional jail time, would be beneficial for the conduct that occurred here. I think the jail treatment program or NeoCap may be helpful in addressing the underlying substance abuse issues and following all recommended treatment aftercare. Thank you.
I've reviewed the pre-sentence report, the victim impact statement. Listened to defendant, listened to counsel. Considered all provisions in 29-29-11, 29-29-12, and 29-29-13. Place you on community control for 4 years. You make that very difficult
Yes, Your Honor.
by your lack of acknowledgement of what you did, your lack of insight into your condition. On probation will be with regard to all 3 counts. With regard to count 1, 117 days in the Lake County Jail with credit for 72. With regard to all the counts, you'll complete the jail treatment program and follow all recommendations. Complete the decision points program and follow all recommendations. You're to have no drugs or alcohol and you'll be screened. You're to obtain and maintain full employment. You're to have no contact with Bossert. And you're going to pay the costs and supervision fees. Anything else, Ms. Randazzo?
Mental health assessment and anger management.
Going to get a mental health evaluation and follow all recommendations. You understand the terms?
Yes, Your Honor.
Any question about the terms?
No, Your Honor.
If you violate, the state will file a motion to terminate your community control. And if I find that you violated, you face 18 months in prison. You understand that?
Yes, Your Honor.
And once you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation's a new felony, you could get an additional consecutive prison sentence for that violation, the maximum of which would be the greater of 12 months or the time you have left under post-release control. Anything else, Ms. Wood?
No, Your Honor.
Ms. Brenneman?
No, thank you, Your Honor.
All right, we're adjourned.
Yeah. 117 minus whatever, he gave you 72 days credit. I think you can.